Hi everyone, in this week's employment video I'm actually unusually focusing on a case update. I don't normally do this because the case can be very fact specific, but I think there's some really good principles that come out of this case in Borg, Neal and Lloyd's banking group. And it concerns a manager in the banking group who uses an offensive term and is subsequently dismissed for use of that term. The tribunal is investigating not only the fairness of the procedure, but then has to judge as well on the proportionality of the decision weighed up against the severity of the conduct. So Mr. Borg-Neal is a long-standing employee of Lloyd's Banking Group. They introduce some remote training, which is titled Race Education for Line Managers. And that was facilitated by way of an external company coming in and training a group of the employees. So during this session, Mr. Borg-Neal asks how a line manager should handle a situation where they hear someone from an ethnic minority using a word which may be considered offensive if used by someone not from that minority. And for the purposes of this video and the tribunal's transcript, he used the N-word in the black community, but rather than the abbreviation, the employee in this case used the full word rather than that abbreviation. So on the face of it, a fairly horrific remark that's been made by somebody in, ironically, equality and diversity training. So the external company reports the matter to the bank. They start an investigation and decide to pursue disciplinary action. They conclude that no offence was intended. It was a legitimate question that they agreed was posed by the employee, but perhaps with the wrong choice of approach in how he did raise that question. They did find that he should have known better and should not have raised the matter in the way that he did in a professional environment. And although he apologised immediately, did not repeat the word, they decided to dismiss for gross misconduct, and a part of the reasoning was that the trainer had apparently taken a period of sick leave because of the impact of the comment having been made in that session. The appeal against dismissal was rejected, and Mr. Borg-Neal then brought claims for unfair dismissal, direct race discrimination, and discrimination arising from disability. Now, the race claim was rejected by the tribunal. I'm not going to go into that. But I'm interested mainly in the unfair dismissal aspect because it's a really interesting examination of how a tribunal approaches these cases. They accepted that the bank genuinely believed Mr. Borg-Neal had committed gross misconduct, and that belief was based on reasonable grounds. Now, that's part of a test that the employer has to comply with in order to justify a fair dismissal, potentially. Now, it wasn't in dispute that he made that remark, and so the bank was entitled to rely on that as evidence of misconduct. So context, unfortunately, for the bank is everything in this case. It's one thing to have the misconduct there and proven. It's another to be able to demonstrate that a proportionate response is to terminate employment. And the tribunal focused on a number of issues against the bank in this respect. He only used the word once. He immediately apologised. His question was relevant and well-intentioned. It wasn't used as a term of abuse, but the aim of the training was to be open and to try and find solutions to certain problems which may arise. And Mr. Borg-Neal was simply raising that challenge and seeing what advice could be given by the external company. The training session began with a script which warned against the use of language, but unfortunately Mr. Borg-Neal was delayed in attending and didn't actually receive that script. The bank placed some quite heavy emphasis on the impact of the comment on other people in the room. There was no direct evidence from the trainer. She did not raise her own complaint, didn't want to participate in the process and didn't explain why. There was no specifics around the trainer's absence, so there was no deep dive into whether the reasoning for that absence was specifically the training or the remark that was made. There were two other trainers present at the session as well. They didn't make any complaint and they weren't interviewed. So to an extent, the investigation was a little bit flawed there, and the bank could have done more to investigate the impact of that comment. So the tribunal actually concluded that a reasonable investigation had not been completed. A reasonable employer could take the view that the word was offensive and insulting, extremely shocking and hurtful, and it's distressing to others and is unprofessional. But that is a separate question as to whether the employee should have been dismissed for having used that term. And it's essentially the second part of the examination that wasn't conducted properly by the bank. The other conclusion that the bank reached in dismissing was that it would condone use of the word if they failed to dismiss. The tribunal disagreed with that, particularly on the basis of the employee seemingly being mortified that he'd caused offence, offering to apologise, suggesting he would go on further training. It consistently demonstrated that he's learned from his actions, and there was immediate remorse showed. So on that basis, the tribunal found that it was an unreasonable investigation which had been conducted. They didn't get many of the answers which they should have done from that investigation. But importantly, this seemingly zero tolerance approach to language such as this did not justify dismissal in the circumstances. And I think that's a really important lesson for employers, that we have misconduct which may on the face of it be extremely serious, and we may be very concerned about the repercussions of not terminating employment where that behaviour is being displayed. But there are all sorts of mitigating factors and proportionality issues which have to be considered in those circumstances. Automatic sanctions for misconduct may well be put in disciplinary procedures as a deterrent or a guide, but there always has to be a rational basis for drawing conclusions which consider the full picture. Just a side note as well, the employee did actually succeed in a claim of discrimination arising from disability. So he suffered from dyslexia, and that was deemed to be a strong factor in causing Mr. Borg-Neal to express himself in the way that he did. So as part of this test, the employer would have to show that the decision to dismiss, was a proportionate means of achieving a legitimate aim in the context of the disability. So their legitimate aim was to further its anti-racist education programme and make it clear that the use of such language was unacceptable. Unfortunately, by dismissing the employee, that was not deemed to be a proportionate way of achieving that aim. There were other things they could have done: issue a warning, further training, allow the employee to apologise to the trainer. So again, we're bringing in this concept of proportionality, and ultimately the tribunal said, yes, the behaviour is extremely serious, but the sanction of dismissal in the circumstances was just not within the range of reasonable responses, and it was not proportionate to do that, given all of the other factors in the case. So I hope you found that video useful. It's a really good examination of what needs to be considered when we are looking at cases which on paper may amount to gross misconduct and may do so under the disciplinary procedure, but there are all sorts of other considerations as well. If you do need to talk about this case further, or the principles, or indeed anything employment law related, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.